Jaya Hind. I am Ara.
Jai Hind. I am Krishna Rai.
Jaya Hind. I am Ram Nivas.
We are sharing with you in this video a judgment of Constitutional Bench of Supreme Court on the issue of legislative and executive power of NCTD and GNCTD on services. A Constitution Bench of Chief Justice of India Dr. Dhananjaya Y. Chandrachud, Justice M.R. Shah, Justice Krishna Murari, Justice Hima Kohli and Justice Pamidighantam Shri Narasimha held that NCTD has legislative power over services, excluding public order, police, and land. Under Entry 41 in List 2, the Lieutenant Governor shall be bound by the decisions of GNCTD on services. The limited issue for the consideration before the Constitution Bench was only related to the scope of legislative and executive powers of the Centre and NCTD with respect to the term services. That is to say, whether the NCTD or the Union government has legislative and executive control over services. The submissions made by the counsel representing the parties as recorded in the judgment are: Dr. A.M. Singhvi, learned senior counsel appearing for the appellant, raised the submissions. These submissions are recorded in the judgment and are:
Argument number 1. The Legislative Assembly of NCTD has the power to enact laws under Entry 41 of List 2 of the 7th Schedule. The power cannot be excluded merely because the entry uses the term state public services and not union territory public services. In fact, the Delhi Legislative Assembly has enacted laws that fall within Entry 41. Argument number 2. Even if it is found that the legislature of NCTD has not exercised legislative power related to Entry 41 of List 2, it does not imply that the power ceases to exist. Argument number 3. NCTD has legislative power and executive power over all entries in List 2 other than entries 1, 2 and 18 which have been expressly excluded by Article 239AA. Argument number 4. The phrase "insofar as such matter" is applicable to union territories in Article 239AA is inclusionary and not exclusionary. Multiple entries in List 2 and List 3 use the term state. The phrase "insofar as such matter" is applicable to union territories is a facilitative phrase which permits such entries being made available to the union territory of NCTD without an amendment of the lists in the 7th Schedule. Without the facilitative phrase, NCTD would not have legislative competence over those entries in Lists 2 and 3 which use the term state. Argument number 5. NCTD is sui generis. It cannot be brought within the common class of union territories. Argument number 6. This court in Union of India versus Prem Kumar Jain, 1976, 3 SCC 473 has recognized that the provisions of Part 14 of the Constitution extend to union territories. Argument number 7. The report of the Balakrishnan Committee opined against the inclusion of services within the legislative and executive ambit of NCTD does not have any relevance because, number 1. It preceded the inclusion of Article 239AA, by which 3 entries from List 2 have been expressly excluded from the legislative competence of NCTD. Number 2. The conclusion that only states, and not union territories, can have services is conceptually wrong. Number 3. The judgment of this court in Prem Kumar Jain, Supra, was not considered, and number 4. The opinion of the majority in the 2018 Constitution Bench judgment expressly notes that the report of the Balakrishnan Committee will not be used as an aid to interpret Article 239AA. Argument number 8. Personnel belonging to All India Services and central government services are governed by the Indian Administrative Service, Cadre, Rules 1954 and the All India Services, Joint Cadre, Rules 1972 respectively. In terms of these rules, While it is the prerogative of the Joint Cadre Authority to make an officer available to GNCTD, the actual posting of the officer within the departments of GNCTD is the prerogative of the latter. Similarly, under DANIX and DANIPS Rules 2003, once an officer is allotted to NCTD, it is the administrator who appoints that officer to a post within NCTD.
Mr. Shardin Farasit, learned counsel appearing for the appellant, provided an overview of the control of services in national capital territories across the world. He argued that regardless of the level of devolution of power in countries across the world, even in countries with centralized forms of government, the power to control services has been devolved upon the local government of the national capital territory. Mr. Tushar Mehta, learned Solicitor General, made the submissions on behalf of the Union of India that
Argument number 1. Entry 41 of List 2 is not available to Union territories, as it cannot have either a State Public Service or a State Public Service Commission. Argument number 2. The 2018 Constitution Bench judgment did not decide whether NCTD has legislative competence over Entry 41 of List 2. Argument number 3. Delhi, being the national capital, enjoys a special status which requires the Union to have control over services, in the absence of which it would become impossible for the Union to discharge its national and international responsibilities. Argument number 4. The expression, insofar as any such matter is applicable to Union territories, in Article 239AA means that the entries contained in List 2 are available to NCTD to the limited extent to which they are applicable to Union territories. The legislative powers of NCTD shall extend to only those matters which are applicable to Union territories. Since the Constitution uses the term applicable and not relating to Union territories, the legislative power of NCTD will extend to an entry only when that entry is clearly and unequivocally applicable to Union territories as a class. Consequently, List 2 has to be read contextually and certain entries can be excluded from the domain of GNCTD. Argument number 5. The control of Union of India over services has not led to any issue pertaining to the governance of NCTD. And argument number 6. The Transaction of Business Rules 1993 provide enough powers to ministers of GNCTD to ensure supervisory and functional control over civil services to ensure their proper functioning. The rules applicable to the civil services indicate that administrative control rests with the Union.
The Constitution Bench final held, and I quote, "We reiterate that in light of Article 239AA in the 2018 Constitution Bench judgment, the Lieutenant Governor is bound by the aid and advice of the Council of Ministers of NCTD in relation to matters within the legislative scope of NCTD. As we have held that NCTD has legislative power over services, excluding public order, police, and land, under Entry 41 in List 2, the Lieutenant Governor shall be bound by the decisions of GNCTD on services. As explained above. To clarify, any reference to Lieutenant Governor over services, excluding services related to public order, police and land, in relevant rules shall mean Lieutenant Governor acting on behalf of GNCTD. The bench finally held and concluded in para 164 of the judgment, and I quote, "A. There does not exist a homogeneous class of union territories with similar governance structures. B. NCTD is not similar to other union territories. By virtue of Article 239A, NCTD is accorded a sui generis status, setting it apart from other union territories. C. The Legislative Assembly of NCTD has competence over entries in List 2 and List 3 except for the expressly excluded entries of List 2. In addition to the entries in List 1, Parliament has legislative competence over all matters in List 2 and List 3 in relation to NCTD, including the entries which have been kept out of the legislative domain of NCTD by virtue of Article 239A, 3A. D. The executive power of NCTD is coextensive with its legislative power. That is, it shall extend to all matters with respect to which it has the power to legislate. A. The Union of India has executive power only over the three entries in List 2 over which NCTD does not have legislative competence. F. The executive power of NCTD with respect to entries in List 2 and List 3 shall be subject to the executive power expressly conferred upon the Union by the Constitution or by a law enacted by Parliament. G. The phrase insofar as any such matter is applicable to Union territories in Article 239A, 3, cannot be read to further exclude the legislative power of NCTD over entries in the state list or concurrent list, over and above those subjects which have been expressly excluded. H. With reference to the phrase, subject to the provisions of this Constitution, in Article 239A, 3, the legislative power of NCTD is to be guided, and not just limited, by the broader principles and provisions of the Constitution. And NCTD has legislative and executive power over services, that is, entry 41 of List 2 of the 7th Schedule because 1. The definition of state under Section 358 of the General Clauses Act 1897 applies to the term state in Part 14 of the Constitution. Thus, Part 14 is applicable to Union territories, and 2. The exercise of rule-making power under the proviso to Article 309 does not oust the legislative power of the appropriate authority to make laws over entry 41 of the state list. That is all in this video. Thanks for watching and stay tuned. Jaya Hind.
Jaya Hind.
Jai Hind.